The House Judiciary Committee hearing room buzzed with tension as Congresswoman Jasmine Crockett adjusted her microphone. C-SPAN cameras swept the chamber, showing a full gallery and a line of witnesses at the long oak table. At the center sat Speaker of the House Mike Johnson, who had taken the unusual step of appearing before the committee to defend his controversial legislative agenda. Moments earlier, Johnson had delivered a polished 20-minute presentation on constitutional principles and the separation of powers. With the confidence of a former constitutional lawyer, he lectured the committee on the founders' original intent and how his leadership was restoring proper constitutional governance. Republicans nodded along. Democrats exchanged skeptical looks. Then Chairman Jim Jordan announced, "The chair recognizes the gentlewoman from Texas, Ms. Crockett, for 5 minutes of questioning." Something in the room shifted. Johnson kept a composed smile as he turned toward Crockett, but close observers saw his fingers tighten slightly around his pen. What followed stunned the room. With a single, carefully crafted question, just 27 words, Congresswoman Jasmine Crockett would undercut Speaker Johnson's carefully built constitutional authority, reveal a core contradiction in his legal philosophy, and leave him stammering before millions of viewers. By the end of her 5 minutes, Johnson's credibility had taken a major hit, and clips of the exchange were already racing across social media. Before we explain how Crockett engineered this takedown with one question, hit subscribe and tell us in the comments where you're watching from. Our upcoming videos will break down more of Washington's fiercest confrontations that rarely get real analysis in mainstream coverage. This clash had been building for months, and the contrast between the two attorneys turned politicians could not have been sharper. Speaker Mike Johnson, 52, built his political brand on being a constitutional conservative. Before politics, he worked as an attorney for the Alliance Defending Freedom, a conservative Christian legal group. His rise to the speakership after the chaotic removal of his predecessor was swift and surprising, with many crediting his selection to a reputation as a constitutional scholar, able to navigate tough legal issues within the caucus. Since taking the gavel, Johnson often cited his legal background to push controversial bills. As a constitutional attorney for more than 2 decades, he would say, using his credentials to reinforce his positions. He regularly appeared on cable news, introduced as a constitutional expert whose analysis carried special weight. His office walls displayed framed copies of the Constitution and the Declaration of Independence, visual signals of his claimed expertise. Congresswoman Jasmine Crockett brought a notably different resume and method. At 42, the freshman representative from Texas arrived in Congress after serving in the Texas legislature. Before that, she built a record as a civil rights lawyer, representing clients in police misconduct cases and fighting for voting rights. Where Johnson emphasized original intent and textualism, Crockett stressed evolving interpretations and how constitutional principles operate in real life. The day's hearing examined Speaker Johnson's legislative agenda, which Democrats said violated several constitutional principles despite his claims of fidelity. Johnson agreed to testify, confident he could defend his positions with his legal expertise. He came prepared with binders of notes and historical references, expecting standard partisan questioning. What he apparently did not anticipate was that Crockett had spent the previous night reviewing his legal career, public statements, and voting record in detail. While other Democrats planned to debate policy, Crockett focused on something more basic, a sharp gap between Johnson's stated constitutional philosophy and his actual legal positions. The stakes went beyond one hearing. This was about who gets to interpret the Constitution, whose expertise the public should trust, and which vision of American governance would shape the narrative. For Johnson, preserving his image as a constitutional authority was key to his effectiveness as Speaker. For Crockett, exposing contradictions would undercut the foundation of his political power. As Crockett arranged her notes, the room fell into expectant quiet. Republicans looked relaxed, confident Johnson could handle whatever came. Democrats leaned forward, curious about their colleague's approach. None of them, Johnson included, expected how thoroughly one precise question would alter the course of the hearing. "Thank you, Mr. Chairman," Crockett began, her voice clear and steady. "And thank you, Mr. Speaker, for appearing before the committee today. Before my main question, I'd like to confirm a few points about your legal philosophy for the record. Johnson nodded confidently. Happy to clarify my positions, Congresswoman. You've described yourself as a constitutional originalist and textualist. Correct? Crockett asked. Yes, that's accurate, Johnson replied. We must read the Constitution according to its original public meaning at the time of ratification. And you've said many times the Constitution should not be treated as a living document that evolves with changing times and social values. Correct? That's right, Johnson said, warming to a familiar point. The Constitution has a fixed meaning. If changes are needed, they should come through amendment, not judicial reinterpretation. Crockett nodded and made a note. And would it be fair to say you believe this originalist approach applies consistently to all parts of the Constitution? Absolutely, Johnson answered. Consistency is essential. We can't pick and choose based on political preference. With those preliminaries, Crockett set the stage. Johnson had stepped into her carefully laid framework, unaware that she was about to use his own standards to dismantle his constitutional claims. Thank you for those clarifications, Mr. Speaker, Crockett continued, her calm tone giving no hint of what was coming. I have one substantive question for you today. She paused, allowing the cameras to frame both her and Johnson, then delivered the question that left the speaker searching for words. Given your commitment to strict originalism, can you explain why you believe the Second Amendment protects an individual right to bear arms when the Supreme Court did not read it? That way until 2008 in District of Columbia versus Heller, more than 200 years after ratification, the hearing room went silent. Several members blinked at the unexpected line of attack. This was not the policy debate Johnson had prepared for. It was a direct test of the consistency of his constitutional method, using one of conservatives' most valued positions on gun rights. Johnson stared at Crockett, his practiced smile slipping. He reached for water, took a sip, and gathered his thoughts. Well, Congresswoman, the Heller decision simply recognized what was always true about the Second Amendment. The right to bear arms has always been an individual right. Crockett nodded thoughtfully. That's interesting, Mr. Speaker, because for most of American history, including the first 217 years after ratification, federal courts generally held it protected a collective right tied to militia service, not an individual right to own guns for personal use. If you're an originalist, shouldn't you follow that original understanding? The question landed like a precision strike. Several Republicans shifted in their chairs. This challenge met Johnson on ground where conservatives believe they are strongest, yet applied their own method against them. Johnson answered more quickly but with a defensive edge. The earlier courts got it wrong. The text is clear. The right of the people to keep and bear arms shall not be infringed. That's an individual right. So, you believe courts can be wrong for over 200 years about the original meaning of the Constitution? Crockett asked, still conversational rather than combative. That seems to undercut originalist claims that the meaning was fixed at ratification and is clear to those who study the historical record. She continued before Johnson could respond. And if we're looking at the text as you suggest, the full Second Amendment reads, a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. The militia clause appears relevant to the original understanding. The room grew more tense. What began as a routine oversight hearing had become a constitutional law seminar in which the self-described expert struggled to keep his framework consistent. Democrats watched with open interest. Several Republicans flipped through notes, searching for a lifeline. Johnson straightened his tie, his relaxed posture replaced by visible strain. The militia clause is prefatory, not limiting, he said. It announces a purpose but does not restrict the right. Justice Scalia explained this thoroughly in Heller. Yes, in 2008, Crockett replied evenly. But we're discussing the original understanding at the time of ratification. If originalism is correct, how could courts, legal scholars, and legislators misread this supposedly clear individual right for over 2 centuries? Doesn't that conflict with the core originalist claim that the Constitution's meaning is fixed and discernible? The trap was now fully Johnson insisted that the Second Amendment had always protected an individual right. Despite centuries of differing interpretations, he risked undermining the originalist claim that constitutional meaning is fixed and unchanging. Yet if he conceded that constitutional understanding can evolve, he would contradict his own legal philosophy. Either stance weakened. His carefully built image as a consistent constitutional scholar. Johnson glanced at Chairman Jordan, perhaps expecting support, but none came. The chairman himself seemed uncertain how to help the speaker escape this constitutional dilemma. The historical record supports the individual rights interpretation when examined correctly, Johnson finally stated, though his tone had lost its earlier assurance, inconsistency in his constitutional reasoning. That statement was specific to that case, Johnson replied, his voice tense. My broader philosophy remains originalist. Does your originalism allow for evolving interpretations when they support gun rights, but not when they protect other rights? Crockett pressed. That seems less like consistent legal theory and more like selective reasoning to reach preferred outcomes. At that moment, the hearing's tone shifted completely. What began as a routine session with a confident speaker defending his agenda had turned into a precise demonstration of constitutional contradiction, brought to light through a few well-placed questions. Crockett had forced Johnson to challenge his own authority on constitutional interpretation. The tension was visible as Johnson struggled to recover. His once assured composure was gone, replaced by unease. He flipped through his notes, searching for talking points that no longer fit the moment. Congresswoman, you're conflating distinct legal principles, he said, trying to sound authoritative. Originalism doesn't deny that constitutional principles can apply to new circumstances. It only asserts that the underlying meaning remains fixed. I appreciate that clarification, Crockett said thoughtfully. So would it be accurate to say that you believe constitutional principles can apply to situations the founders couldn't have anticipated? Yes, within reasonable limits, Johnson replied, seemingly relieved. That's interesting, Crockett continued, because when the Supreme Court used that same reasoning to recognize privacy rights in Griswold versus Connecticut, or marriage equality in Obergefell versus Hodges, you denounced those rulings as judicial activism. Yet you praise that same interpretive method when it broadens Second Amendment rights, rights unrecognized for most of U.S. history. The room fell silent. Republican members avoided eye contact, while Democrats exchanged quick glances of disbelief at Crockett's precision. Rather than arguing ideology, she was exposing inconsistency in Johnson's judicial philosophy. Those cases created new rights not found in the text, Johnson countered, his tone defensive. The Second Amendment explicitly mentions the right to bear arms, he added, and the 14th Amendment explicitly mentions equal protection under the law, Crockett replied calmly. Yet when courts use that text to protect same-sex couples, you called it activism. When courts expanded the Second Amendment to protect individual ownership, a concept not recognized for 2 centuries, you called it true originalism. The inconsistency is clear. C-SPAN cameras caught Johnson loosening his tie as perspiration gathered on his forehead. Chairman Jordan checked the clock, perhaps wishing the exchange would end, but Crockett still had over 2 minutes remaining. Mr. Speaker, she continued professionally, I'd like to submit for the record your 2019 statement claiming that the Constitution's meaning was fixed at ratification and doesn't change with political trends. Do you still stand by that? Of course, Johnson replied, relieved by what seemed a simple question. Then how do you reconcile that with your Second Amendment stance? Crockett asked. If the Constitution's meaning is fixed, how do you justify supporting an interpretation not recognized for more than 200 years after ratification? Doesn't that contradict your own principle? The trap was now fully set. Johnson faced an impossible choice: maintain that the Second Amendment had always protected an individual right, thereby undermining originalism, or admit that interpretations evolve, contradicting his own philosophy. The historical evidence supports him, he began, then stopped, realizing the corner he was in. Respectfully, Mr. Speaker, Crockett said, her tone calm but firm, what the evidence shows is that you apply originalism when it supports your politics and abandon it when it doesn't. That isn't constitutional fidelity, it's constitutional. Convenience, the gallery murmured. Reporters typed rapidly, aware of the significance of the moment. A first-term Congresswoman had just dismantled the constitutional credibility of the Speaker of the House using his own words. Johnson's final response was faint. The courts have settled this. Heller is the law of the land. Yes, Crockett agreed. just as Obergefell is for marriage equality and Griswold for privacy rights. Yet you celebrate one and condemn the others, even though all represent evolving interpretations of the Constitution. The difference seems to be not your legal principle, but your politics. She turned to the chairman. No further questions. I request to enter into the record the Speaker's 2019 statement on originalism, his Sylvester V. Becerra brief advocating evolving constitutional understanding, and his public criticisms of Obergefell and Griswold as judicial activism. Without objection, Jordan muttered quickly. As the clerk collected the documents, silence filled the room. Republican members avoided eye contact with Johnson, while Democrats exchanged restrained looks of astonishment. Johnson sat rigidly, his authority visibly diminished. The self-proclaimed constitutional expert had been exposed. The exchange revealed a deeper issue within today's constitutional debates: the inconsistent use of legal interpretation methods depending on desired outcomes. Its effects reached well beyond academic discussion. Conservative legal groups that had long promoted Johnson as a constitutional scholar suddenly found themselves in a difficult position. Many released cautious statements reaffirming their belief in originalism, without directly referencing Johnson or the hearing. The Federalist Society, which had often hosted Johnson as a featured speaker, quietly postponed his next symposium appearance. For Johnson, the encounter dealt a significant blow to his reputation as a constitutional authority. Much of his credibility as speaker relied on his image as an expert in constitutional interpretation. From that moment, each time he cited originalism or constitutional fidelity, critics pointed to Crockett's questioning as proof of his selective use of those principles. Media coverage of the exchange lasted for days, with commentators from across the political spectrum offering analysis. The New York Times published an article titled, "When Originalism Meets Political Convenience, the Johnson Contradiction," while the Wall Street Journal took a somewhat sympathetic stance, suggesting that Johnson's position, though imperfectly expressed, showed a more complex understanding of originalism. Even that article, however, acknowledged his failure to clearly communicate this nuance under direct questioning. The clearest sign of the exchange's impact appeared 2 weeks later during a press conference. When a reporter asked Johnson about a constitutional issue in upcoming legislation, the speaker, once eager to lecture on constitutional matters, answered briefly, then deferred to the Judiciary Committee chair. His once confident explanations of originalism were now markedly restrained, subdued by one precisely crafted question. For Representative Jasmine Crockett, the exchange elevated her national standing. Major news outlets and publications sought interviews. Law schools invited her to discuss constitutional consistency. Democratic leaders took notice of her sharp performance in committee hearings, and donors began viewing her as a rising political figure. In her Texas district, constituents held watch parties to view the viral clips, proud of their representative's commanding display. When Crockett finally discussed the exchange in detail on a Sunday morning talk show, she remained composed and deliberate, the same demeanor that had made her questioning so impactful. She emphasized that her approach wasn't about partisan politics, but about maintaining consistency in constitutional interpretation. "We can disagree in good faith about methodology," she said, "but we must apply whichever method we choose consistently. Otherwise, it's not interpretation, it's rationalization." Asked whether she had designed her question to trap Johnson, Crockett smiled. "I prepared thoroughly, as any attorney should." Speaker Johnson has built his political image around his constitutional expertise. When someone does that, it's fair to test whether their principles are consistent or just convenient. The confrontation between Crockett and Johnson would later be studied in political science and law courses as an example of effective congressional questioning, constitutional integrity, and the risks of selectively applying legal principles. It also signaled a shift in public expectation. Broad surface-level references to originalism or living constitutionalism were no longer enough. Citizens were beginning to demand coherence and intellectual honesty in legal arguments. Members of Congress from both parties became more cautious in framing their constitutional positions, knowing that inconsistencies could now be publicly exposed. Even 6 months later, when Johnson attended a conservative legal conference, he was still questioned about the encounter. His answers had evolved into a more nuanced explanation, acknowledging that originalism involves complex historical analysis that can sometimes yield unexpected outcomes. This version of his view, while more defensible, lacked the confident simplicity that had once defined his rhetoric. For Crockett, the outcome extended beyond personal gain. She demonstrated that well-prepared substantive questioning could cut through political performance and expose genuine contradictions. In later hearings, both witnesses and lawmakers grew noticeably more careful when she began to speak, aware of her precision in identifying inconsistencies. Ultimately, the Crockett-Johnson exchange became a rare instance where substance prevailed over showmanship. A single, carefully designed question reshaped public discussion on constitutional interpretation, proving that intellectual consistency carries greater weight than political convenience. If you found this analysis of how Congresswoman Jasmine Crockett challenged Speaker Mike Johnson insightful, make sure to like this video and subscribe to the channel. Let us know in the comments which political exchange you'd like us to cover next. And turn on notifications to catch our upcoming video on 5 questioning techniques Crockett uses that you can apply in everyday debates. Thanks for watching, and see you in the next one.